The Code of Criminal Procedure forms the backbone of criminal law proceedings in India. While the CrPC or the new BNSS itself doesn't explicitly define certain commonly used terms, these have evolved through practice and interpretation. In this video, we aim to clarify the meanings and implications of these terms, which are crucial for understanding the various stages of criminal proceedings. The journey of a criminal case often begins with the first information statement, a term derived from Section 154 of the CrPC corresponding to Section 173 of BNSS. Although the word first is not explicitly used in the section, the FIS is understood to be the initial information given to the police about a cognizable offense. The person providing this information is known as the first informant, a term that distinguishes their role in initiating the criminal proceedings. Following the receipt of this information, the police create a first information report. This term evolved from a combined reading of Sections 154 and 157 of the CrPC, corresponding to Section 173 and 176 of BNSS, refers to the first report sent by police to the magistrate after registering a cognizable offense. The FIR's significance lies in its status as the first official record of the incident reaching the court, and it cannot be tampered with later as the original is immediately sent to the magistrate court. As the investigation progresses, it culminates in the final report, based on Section 173 Clause 2 of the CrPC corresponding to Section 193 Clause 3 of BNSS. This report, filed by the police upon completion of their investigation, contains the conclusions drawn from the collected evidence. While Section 173 Clause 2 of CrPC corresponding to Section 193 Clause 3 of BNSS simply refers to it as a report, and Section 2 Clause R of the CrPC corresponding to Section 2 Clause 1T of BNSS calls it a police report, the term final report has gained widespread use in legal parlance to convey its nature as the culmination of the police investigation. The final report can take one of two forms, a charge sheet or a refer report. Charge sheet is filed when the police decide to prosecute based on the evidence gathered. Conversely, a refer report, also known as a closure report, is filed when the police decide to close the case due to lack of evidence or other reasons. These terms, while not used in the CrPC or the new BNSS, have become standard in legal practice to clearly convey the outcome of the police investigation. In cases where the police file a refer report, an aggrieved person still has recourse through a protest complaint. This allows the complainant to approach the magistrate with their complaint despite the police's decision to close the case. The term protest complaint helps distinguish such complaints from other general complaints filed in court. It's worth noting that in police charge cases, while the state is the official complainant, the term de facto complainant is used to identify the actual aggrieved person. Throughout the investigation process, the police maintain various records, including the case diary statement. This term refers to witness statements recorded by the police during their investigation under Section 161 Clause 3 of the CrPC corresponding to Section 180 Clause 3 of BNSS. It's important to note that there is often confusion between the concepts of case diary and police diary. Section 172 Clause 2 of the CrPC corresponding to Section 192 Clause 4 of BNSS mentions the police diary, while Section 172 Clause 1A of the CrPC corresponding to Section 192 Clause 2 of BNSS introduces the term case diary. In practice, police often incorporate both the police diary and witness statements in one common file called the case diary file. If you found this video helpful, please like and share it with others. Subscribe to our channel for more legal insights.